Good evening, gentlemen. I'm sure we all had quite an awesome and blissful day. You're welcome to tonight's online session. I'm still your host, O.O. Stevens, and we are going to be looking at the topic enforcement of judgment. Enforcement of judgment in civil litigation. Now, what is enforcement of judgment? This is the process whereby a judgment or order of court is enforced or carried out. Now, most judgments require compliance with their terms. So it is only in the case of a declaratory judgment that merely declares what the right of a party is without imposing any sanction on the defendant or directing either of the parties to do anything, that execution is not called for or levied. So if you listen to our voice note on closing address and judgment, you will notice that we exhaustively discuss the concept of a declaratory judgment. And we say that a declaratory judgment is a type of judgment that does not require any party to perform any action, or that does not impose an obligation on anybody to carry out anything. So in a declaratory judgment, it will not be enforced. So there is nothing like the court enforcing its judgment. And when we talk about enforcement of judgment of the court, this is a process whereby the judgment that was given by the court is carried out. Now, enforcement of judgment will not be necessary where the party against whom judgment was given decides to willingly carry out that judgment. So, for instance, if the court asks you to pay Mr. A the sum of 1 million naira as the judgment debt, and you willingly paid Mr. A that sum of 1 million naira, then there will be no requirement for enforcement of judgment. So judgment of the court is only required to be enforced where the judgment debtor refuses or neglects to carry out the judgment that has been given by the court. That is the only time that there would be a need for the court to enforce its judgment. This is because the court always guards its judgment with jealousy. So once it gives judgment, it must be enforced. It must be enforced, except that there is any pending order that is maybe holding that judgment from being enforced. Maybe you filed an appeal and you filed an application pending appeal. So in such an instance, the court of appeal or the appellate court may give an order restricting that judgment from being carried out. And remember, we have already told you that when the judgment debtor decides to willingly do what the court has ordered, then there will be no requirement for enforcement. So in other words, enforcement of judgment really require the court to also come in again. So enforcement of judgment requires the court to also come in again. So after the court had already given its judgment, then when it is about time to enforce it, then the court will also make another type of order. And that is what will now launch us to the mode of enforcement of judgment. That is what will now launch us to the mode of enforcing the judgment of the court. And this mode of enforcing the judgment of the court, we are going to be looking at various types of modes. The first one we are going to take is writ of FIFA. Writ of FIFA. Some people call it writ of FIFA, but it is FIFA is just the short form of pronouncing fiera facies. Fiera facies. Now, this writ of FIFA, you can also call it writ of attachment. You can also call it writ of attachment. So, for instance, now judgment was actually given against a judgment debtor, and he refuses to carry out, or he refuses to do what the court has actually asked him to do. Then you, who is the judgment creditor, can approach the court again and tell the court that the judgment debtor has refused to do what you have asked him to do, or he has refused to give me what you have asked him to give me. So this will really make you to understand now that there is no requirement to enforce judgment when it is a declaratory judgment, because nobody is expected to do anything for anybody in a declaratory judgment. But if it's executory judgment, that is when there is an obligation placed on a particular party to carry out an action, then when such a party fails, that is when there will be a need for enforcement of judgment. And we are now saying now that one of the modes of enforcing judgment is by way of the court granting what is known as writ of FIFA or writ of FIFA. Now we now say now that in this writ of FIFA, you can also call it writ of attachment. And this is against the movable property. This is against the movable property of the judgment debtor. So where the goods or other movable properties of the judgment debtor are attached under this writ of FIFA, they shall not be sold until after the expiration of 5 days unless it is where the goods are of perishable nature or where the judgment creditor requests that the court should allow the goods to be sold before 5 days. So what we're talking about now is that movable properties of the judgment debtor can be attached. Attaching it means once the court gives this order, this writ of FIFA, then you can actually use it and attach any movable property like his cars, like his clothes, but you really make sure that you don't actually attach his wearing apparel. You don't attach his wearing apparel or his working tools. So you don't attach those ones. So the things he wear or the tools he uses to work, you don't attach it. So you attach other things like maybe his car, maybe anything that can be moved, from a place to another. That is what writ of fair is meant for. And most often than not, writ of fair is often the first type of order granted by the court with respect to enforcement of his judgment. And I've already told you now that when the movable goods or when the movable properties of the judgment debtor have been attached, such cannot be sold until the expiration of 5 days, except they are perishable goods or where the judgment creditor specifically requests and the court grants it. But there are some instances whereby you may be done with attaching the movable property of the judgment debtor, and that movable property of the judgment debtor cannot be able to offset the judgment debt. Now you are allowed to come back to the court, but the court you're coming back to now is the High Court. So assuming now it was the magistrate court that granted you the writ of fair, the magistrate court cannot grant you another order against the immovable property of the judgment debtor. So it is only the High Court that can grant what is known as writ of execution against the immovable property of the judgment debtor. So if the movable property cannot be able to offset the judgment debt, then you can approach the court, that is the High Court, for the immovable property of the judgment debtor to be attached. So that is what you need to know. And when we talk about movable property, just like a house, somebody's house, somebody's land, so you can attach it to be able to sell and get your the remaining balance of the judgment debt. So this, both the writ of execution and the writ of fair, they are all writ of attachment and sale. So you attach the property of the person and you sell it. So if it is the immovable property of the judgment debtor, then it cannot be sold after attachment. It cannot be sold until the expiration of 15 days, except the judgment creditor requests otherwise in writing. And in case of the immovable property, the purchaser's title is voidable for a period of 21 days from the sale and can only become absolute afterwards. What we're talking about now is, even if the immovable property has been sold, the person that the property is sold to, his right or his interest in the property will be voidable. Voidable means that the judgment debtor can still come within 21 days after the sale has been made to the purchaser and redeem the judgment debt and take his property back. But if he didn't do that until the expiration of the 21 days, then the rights of that particular purchaser will become absolute. And the court will now issue him with a certificate of title, meaning that he's now the owner of that particular property. And sale of any attached property is always by public auction and not by any private arrangement unless the court directs otherwise. So anything that has been attached as a way of a judgment debt cannot actually be sold through private arrangement. The sale must be by public auction so that transparency will be seen. All right, we have garnishee proceeding. This garnishee proceeding is better explained. Now, there could be an instance whereby the court gave judgment against me. And you know that when judgment is given against me, I am by that condition known as a judgment debtor. Now, I didn't want to perform the obligation that has been imposed on me by the court, maybe to pay so person the sum of maybe 100,000 or 200,000 or anything. Then the judgment creditor now noticed that I have an account or I have money in ABC Bank. And he noticed that that money that I have in ABC Bank can be able to pay off this judgment debt. Then he will now approach the court by way of an application. An application for garnishee is always by way of motion ex parte. So he will now apply to the court, telling the court that this particular judgment creditor has an account or has the money in his account with ABC Bank. Then when that application has been made, because every application is always supported with an affidavit and a written address, so it is in your affidavit that you're going to x-ray these facts to the effect that the judgment debtor has an account and has so amount of money, and you are saying this from a very reliable source. He has it with the other with the bank, with ABC Bank. Then the court will now issue an order to that particular bank, requesting the bank to come and state whether this man indeed has an account with them, and if the man has an account with that man also has that particular money that has been stated. Now, when the bank is requested to come and make any type of input or defense, or maybe file their own counter affidavit or affidavit to that effect, now the implication is that what that is called is Ganishi Nisi. Ganishi NISI. And the implication of Ganishi Nisi is that the judgment debtor cannot access that account unless with the order of the court. So pending that period that the bank is going to reply the court, letting the court know that what this man is saying is either true or not, the judgment debtor cannot access the account. That is that type of situation whereby you have something like temporary forfeiture of an account, and temporary freezing of an account, and permanent freezing of an account, or temporary forfeiture and permanent forfeiture of a property. So now that particular period now is when the bank would come and let the court know whether this judgment debtor has an account with them or not, and whether that particular money is there. So if the bank probably replies the court and lets the court know that yes, this young man indeed has this money and it is his own, then the bank can now make an order known as Ganishi Absolute. Ganishi Absolute now would be requesting the court will now be requesting the bank to pay the judgment debtor from the account, pay the judgment creditor from the account of the judgment debtor. Judgment creditor is the person whom judgment is given in his favor, while judgment debtor is the person against whom judgment was given. So the court will now make an order requesting the bank to pay the judgment creditor from that particular account. That is when it becomes Ganishi Absolute. Now, what I want to explain now is, for the purpose of this particular discourse, the bank is called the Ganishi, and the judgment creditor is known as the Ganishor. And the reason why it is always by way of motion exparte is because there is no requirement of communicating the judgment debtor. You don't communicate him because it is motion exparte. So it's only the bank that you will now inform, and the bank, for the purpose of the proceeding, is known as the Ganishi. So it is the bank that is holding the person's money that is the Ganishi. It is not the judgment debtor. Judgment debtor is not the Ganishi. Judgment debtor is just judgment debtor. So you, the judgment creditor, is the Ganishor, and the bank that you want to attach that particular the particular money of the judgment debtor is the Ganishi. So that is one thing you need to appreciate and understand about the concept of Ganishi proceeding. So somebody must definitely have money in another person's account, and that other person in whose account that money is would now be requested to come and state what he knows about the account and about the money in it. Then if the court is satisfied, then the court can now make another order known as Ganishi Absolute, where from the money is going to be paid to the judgment creditor. Alright, we have another mode of enforcing judgment known as judgment debtor summon. Judgment debtor summon. This is where a judgment debtor will be summoned by the court to come and state the reason why he has refused to pay the judgment debt. To come and say the reason why he has refused to pay the judgment debt. And on the date fixed for the hearing, the judgment debtor will be examined on oath as to his means, and the following are the orders that the court may make. So he may be examined on oath as to his means. Now is, how much are you making? How much can you be able to give? And after the court has actually finished examining him, then the court may make the following order. One, the court may make an order committing the judgment debtor to prison for a term not exceeding 6 weeks if the court finds out that he intentionally defaulted from paying. So he can be remanded in prison custody, but such shall not be beyond 6 weeks. The court may also make an order that the judgment debtor's property be attached and sold. The court may make such an order. The court may also make an order for payment of the money by installments. These are the orders that can be made after a judgment debtor summon. The court may make an order for the for the payment of the money to be made by installments. The court can also make an order discharging the judgment debtor from prison. So all these things are the likely orders that can be made by the court. And with respect to payment by installments, this is a situation where the judgment debtor brings an application by way of motion or notice for the court to grant an order for him to pay the judgment debt in installments. So this is another mode of enforcing judgment. For instance, now after the court has given judgment, the judgment debtor may actually believe that, okay, paying this sum of 1 million naira once may be so much for me. Then he can apply to the court by way of motion on notice, requesting the court for him to pay the particular judgment debt by installment. But however, upon default of payment of one installment, all the outstanding sum will become payable, and the judgment creditor can bring an application to levy execution. So assuming now you say that you're going to be paying the sum of 200,000 naira per month, and you fail to pay for 1 month, then assuming the money is still remaining 600,000, now all those 600,000 will now become payable once. But this is only when the judgment creditor brings an application letting the court know that you have defaulted to pay for 1 installment. All right, let us look at execution of judgment for recovery of premises. In this execution of judgment for recovery of premises, we are going to be discussing 2 key terms. We're going to be discussing the term writ of possession, and we're going to be discussing the term warrant of possession. Now, assuming I am in court with my brother as to who has title to a particular piece of land, or assuming people are in court as to a title to a property. Title to a property, who owns it? That we're talking about that. Now, if the court finally determines that out of the A and B, it is A that has title to that property, now, and B refuses to leave, then A can actually come back to court after the expiration of 14 days. So in other words, B has 14 days to leave that particular property. So you don't come and execute any judgment against B except after the expiration of 14 days with respect to title to property. So now, if at the end of the 14 days, B is still on that particular property, then A can come back to court and let the court know that B has refused to willingly leave. Then the court will now issue what is known as writ of possession. The court will now issue what is known as writ of possession. But where it has to do with landlord and tenant, a tenant has been asked to leave the house of this landlord, because in landlord and tenant there is no issue of title, there is no issue of who owns the house. We already know that the house is owned by the landlord. So the court has already told you, the tenant, leave this man's property, you refuse to leave. Then that landlord can come back to court after the expiration of the period given to you by the court. The landlord can approach the court back, and the court will now issue what is called warrant of possession to eject you from that particular property. So just note that writ of possession is with respect to when judgment is given as to title, while warrant of possession has to do with landlord and tenant relationship. Warrant of possession is only with respect to landlord and tenant relationship. Why I'm sounding this is because most often than not, this comes out in MCQ question. So warrant of possession, the type of mode of executing landlord and tenant judgment, is by way of warrant of possession. So it is worthy of being noted. Now let us look at execution of judgment relating to delivery of goods. This shall be enforced by writ of delivery. It is addressed to the sheriff, requiring him to seize the goods wherever they may be found within the jurisdiction of the court and deliver same to the judgment creditor. So for instance, now you are expected to come and deliver goods to me, and you refuse to do that, and I take you to court. Now the court may now issue what is known as writ of delivery. After the court has finally told you, deliver this man's goods to him, and you refuse. So the court may issue what is known as writ of delivery. That writ of the delivery is to the effect that anywhere that goods are actually found, because the writ of delivery will be addressed to the sheriff. Sheriff is just like the court police, the officers of the court that enforce the judgment of the court. They are known as sheriff. So the writ of delivery will be addressed to them, requiring them that anywhere they see those goods, they are empowered to seize the goods and return them to the judgment creditor. So that is it. Now we also have another way of enforcing the judgment of the court by committal order. Committal order is where a person who fails to comply with the order of the court, other than an order for payment of money, the court may order that he be committed to prison and detained until he obeys. So if the order of the court is not with respect to payment of money, then the court may commit such a person to prison. For instance, if you have been asked to leave a particular land and you refuse, the court may not even bother itself to even issue writ of possession against you. The court may decide to angrily commit you to prison, because remember we said that the court guards its judgment with jealousy. Now we have writ of sequestration. In this writ of sequestration, for instance, there could be a scenario whereby somebody who is a judgment debtor refuses to pay the judgment debt, and he owns, let's say for instance, a hotel, and money comes into this hotel regularly. Now when he refuses to pay, the judgment creditor can approach the court, and the court can appoint other officers of the court, not less than 2 persons. They are known as sequestrators. They are called sequestrators. And the purpose of appointing them is for them to enter into the property of the judgment debtor and collect every proceed or gain that accrue from such a property. For instance, these sequestrators can come to the man's hotel, and they will now become those that will be collecting any money that anybody is paying with respect to lodging and accommodation. So the essence of doing that is for them to use any money that enters into this particular property for the purpose of offsetting the judgment debt. So they are not coming to sell the property. They are coming to just any gain accruing from the property will be used to offset the judgment debt. So you can use this now and differentiate between writ of FIFA. In writ of FIFA, there is a sale. In writ of FIFA, you attach and you sell. But in this one, you don't sell. The sequestrators just enter into the property of the person, and they will seize it, and it has to be the movable property. They will seize it, and they will be collecting every gain or rent that is accruable, even if probably the man has maybe a hostel or an apartment where people are actually living and paying rent. The sequestrators can be empowered by the court to come and be collecting the rents from those tenants. So it's not going to be going into the hands of the judgment debtor again. It will not be going into the hands of the officers of the court. And the purpose of so doing is to offset the judgment debt. And once the judgment debt has been liquidated, they will now leave the property for the judgment debtor, and he will continue with his business. So that is it about writ of sequestration. So whenever there is writ of sequestration, that is what it's all about. Now let us look at enforcement of intrastate judgment. Intrastate means within the same state. For instance, now judgment is given in Buhari and is expected to be executed in Kubwa. It is intra-state. Judgment is given in Matama and is expected to be executed in Wuse. It is intra-state. So a judgment delivered in a court that is expected to be executed intra-state, the registrar of that court that issued the writ of execution, called the home court, will send the process of execution to his counterpart in the division or district where the process is to be executed, called the foreign court. The implication of this means that if it is a high court that is in Buhari that gave this judgment, and the judgment is expected to be delivered in something is expected to be executed in Wuse. So the registrar of the high court in Buhari here will issue a document to the registrar in that Wuse high court, letting him know that there is a requirement to execute judgment of the high court of Buhari in his jurisdiction, and the process is expected to be accompanied by a warrant in Form 11. That Form 11 now will be requesting and authorizing the execution in that foreign court. And the registrar of the foreign, please, we are calling for the purpose of what we are discussing now. The High Court of Buhari gave the judgment. The High Court of Buhari is called Home Court, and the High Court of Wuse is to execute the judgment. It is called Foreign Court. So what we are now saying now is that now when the registrar is now issuing it, he will accompany by a warrant in Form 11 requiring that particular registrar in Wuse High Court to execute this judgment. And the registrar of that Western High Court now will now execute it as if it was issued by his own court. And after the execution, the registrar of the foreign court shall now file a report to that home court in Form 12. In Form 12, so reporting that the judgment has thus been executed. Now, what about interstate execution of judgment? What about interstate enforcement of judgment? This applies in circumstances where judgment given in one state is to be executed in another state. For instance, judgment is given in Lagos State and is expected to be executed in Taraba State. That is interstate. Now, to achieve this, the judgment creditor will apply to the registrar of the court that gave that judgment to issue him with a certificate of judgment. And when he has been issued with this certificate of judgment, the judgment creditor shall now take the certificate of judgment now, which must be signed and sealed by the registrar. He will now take it to the registrar of the court of similar jurisdiction in the state of execution. So the state where this judgment is to be executed, he will now take that certificate of judgment now to the registrar in that state. And the registrar in the state of execution now will now enter the particulars of the judgment in a book called the Nigerian Register of Judgments. The Nigerian Register of Judgments. So he will enter the particulars of that judgment in it, and he will now have the judgment enforced. However, before the judgment can be enforced on registration, the judgment creditor must depose to an affidavit stating that the amount in the process has become due but unpaid, and that the act ordered to be done remains undone. So he must actually show that in an affidavit that this thing that the court has actually asked to be done has actually remained undone. Remember, we said that the only time that there will be a requirement for enforcement of judgment is when the person against whom judgment was given refuses to willingly carry out the judgment. So when he can actually show that the person has disobeyed carrying out the judgment, then that is the only time there will be a requirement for enforcement of judgment. Now, we also have enforcement of foreign judgments. In Nigeria, enforcement of judgment of the court of a foreign country by a Nigerian court is achieved by either action at common law or reciprocal enforcement. So it can be either action at common law or reciprocal enforcement. Now let us look at action at common law. At common law, a judgment of the court of one country, that is common for common law countries now, that is what we are discussing now. At common law, a judgment of the court of one country may be enforced in another country by way of an action commenced in the court of that other country with the judgment as the cause of action. What are we talking about? For instance, if a court in the UK probably gave judgment, and that judgment is expected to be enforced in Nigerian court. But first of all, note that it must be a court that has a hierarchy with our high court in Nigeria, that its judgment can be enforced here. So if it's a court that its status is equivalent to the status of our magistrate courts here, then their judgment cannot be enforced. So it must be a court that is equivalent to our high court in Nigeria here before his judgment can be enforced. So you need to note that. So now what we're now saying now is, if for instance now the judgment has been given by a court that has equivalence in legal or judicial status with our high court here in Nigeria, then that particular judgment that has been given in that foreign country will now be instituted. That particular judgment creator will now come back to Nigerian court. Now he will now institute another action, a fresh action, but he will not be using that judgment that has been given in the foreign court as his course of action. So that thing that was a problem that was already determined in that particular foreign country will no longer be a course of action. The course of action now is now going to be that judgment that has been given and which has actually dispensed or determined the matter. So that will now become the course of action in Nigeria now. And the court in Nigeria shall now consider many factors after which the judgment of that foreign court will be enforced as though it was the judgment of Nigerian court. Now, for the enforcement of action to be successful, the foreign judgment must meet the following requirements. So for that particular enforcement to be successful in Nigerian court, that particular judgment of the foreign court must meet the following requirements. One, the judgment must be final and conclusive. It must be final. If it's a type of judgment that condition is placed on it, it's not final. So it must be final and conclusive. So the court must have stamped it that this is what it has said to be done. Also, the judgment must have been delivered by a court of superior jurisdiction. I said it earlier. Superior court of record now is a court from our high court up. So those are known as court of. So it must be a court of superior jurisdiction in that foreign country. Also, the judgment must be for a definite sum of money, provided that it is not money recoverable as debt, as fine, as tax, or as penalty. So it has to be probably a debt that you are owing somebody. If it is tax, maybe that you didn't pay tax in that foreign country, then Nigerian courts cannot actually enforce it. That is what we are talking about here. Now, if the judgment is for a right, that is for a property other than money, the property must have been situated at the jurisdiction of the foreign court that gave the judgment as at the time of delivery. So if it is with respect to of executing on a property that is not money, then that property must have been, for instance, now if it's a car or if it's a house, that particular property must have been in the jurisdiction of that foreign court where it was given at the time that the judgment was actually delivered. Now let us look at enforcement by reciprocal enforcement. We have reciprocal enforcement. We know we talked about two ways of executing foreign judgment. We said that we have enforcement at common law and we have reciprocal enforcement. We are now trying to discuss reciprocal enforcement. Now, enforcement of foreign judgment under this process is done on the basis of reciprocity. This is, the foreign country whose court delivered the judgment must also be ready to enforce the judgment of Nigerian courts too. So reciprocity now means that that particular country whose court that Nigeria is about to execute its judgment, even if it's not the common law country, no wahala. So that particular court now whose court that Nigeria is about to execute its judgment, that particular country will also be willing, whenever Nigerian court gives judgment to that particular country, if it is to be executed in that country, that particular country will also be willing to execute or enforce Nigerian judgment. So the judgment given by a Nigerian court in that foreign country. Now, and such countries that render reciprocal enforcement to Nigeria are those to be listed in the order made by the Minister of Justice under Part 1 of the Foreign Judgment Reciprocal Enforcement Act. So it is the Minister of Justice or the Attorney General of the Federation that will now list the countries that has bilateral relationship with Nigeria with respect to enforcement of the bilateral judgment, that is the judgment given by any of the countries. Then the countries that have actually signed this treaty with Nigeria, they have been listed in Part 1 of the Foreign Judgment Reciprocal Enforcement Act. This discourse is mainly for the purpose of our residual knowledge. Most often than not, is a remote area for exam, but you don't take anything for chance or for granted with respect to Nigerian law school. So on that, we're going to be drawing the curtain on this particular topic, enforcement of judgments. And please remember the key areas that we have touched, so that when you are doing your associative reading, you will be flowing very well. And until I meet you again, do take good care of yourselves and have a very peaceful evening.